What is hearsay testimony in a criminal trial? Imagine sitting in a courtroom, hearing someone say something about what someone else told them. You might wonder, can this kind of statement be used as evidence? Well, that's where hearsay comes into play. Hearsay testimony in a criminal trial refers to a statement made outside of court by someone who is not currently testifying, which is then presented in court to prove what it says is true. It's like hearing a rumor and trying to use it as proof. In simple terms, hearsay is secondhand information. It's what a witness heard from another person, not what they saw or experienced themselves. This statement can be spoken words, written messages, or even nonverbal actions that are meant to be taken as an assertion. The person who originally made the statement is called the declarant, but they are not in court to answer questions or be cross-examined. The main reason hearsay is usually not allowed as evidence is because it's not tested in court. Since the declarant isn't there, the jury can't see them cross-examine or challenge the statement's accuracy. This could lead to unfair convictions based on unverified information. The law aims to prevent that by generally excluding hearsay evidence. However, there are exceptions. Sometimes hearsay can be admitted if it's considered trustworthy or if it's used for a purpose other than proving the truth of the statement. For example, if the statement shows the declarant's state of mind or motive, it might be allowed. But these exceptions are narrow and must meet specific rules. From a criminal defense point of view, the hearsay rule is a key protection. It helps make sure that evidence against a defendant is reliable and that they can challenge it. Defense attorneys often object to hearsay to keep potentially unfair or untrustworthy evidence out of the trial. Remember, if a statement is offered to show what someone said, and not to prove that what they said is true, it's usually not hearsay. For example, if a witness says, "I heard the defendant say he was guilty," that's hearsay. But if the witness says, "I heard the defendant say he was feeling anxious," to show the defendant's state of mind, it might not be hearsay. Understanding hearsay and its limits is important because it affects what evidence can be used in court. It's a safeguard to ensure that the evidence presented is fair and that the defendant's rights are protected. The rules around hearsay can be complex, but they are designed to keep trials just and truthful.